Thank you very much.
The prosecution team now reveals that out of its original list of 42 witnesses, 16 have since withdrawn. Most of them reportedly cited threats, intimidation and fear of reprisals as their reasons for doing so. Others, the team believes, were bribed to recant their statements. Prosecutor Fatou Bensouda's team claims it has been deprived of a significant portion of the incriminating evidence that it intended to present to the trial chamber in support of its charges. The application filed yesterday reads in part, quote, "The central issue for determination in this request is the admissibility of records of prior interviews of missing and recanting witnesses who succumbed to improper influences." End of quote. Should the chamber grant the request, the prosecution says it will rely on the prior recorded testimony of the alleged corrupted witnesses thereon to establish the guilt of the accused. But while the prosecution claims that the witnesses were influenced to change their previous truthful accounts in favor of the accused, the defense argues that the witnesses, after being compelled to testify, stated before the judges that their original accounts were untrue and that they did not want to repeat falsehoods. The prosecution's application relies on the amended provisions of Clause 68 of the Rules of Procedure and Evidence. The amendment states that prior recorded testimony can be introduced in court instead of hearing the witness in person when he or she is unable to physically present in court for various reasons, including death, disappearance, sickness, or any other compelling reason. But the defense argues that the amendment was made during the Assembly of States Parties in November 2013, well after the trial against the Deputy President had begun. Ruto's lawyers argue that allowing this application would amount to retroactive application of the rule. The defense team further contends that the prosecution was given the opportunity to cross-examine their own witnesses who had been declared hostile and yet did not prove that the original accounts were actually true. The prosecution insists that failure to admit the prior recorded testimony of the witnesses in question would deny the chamber the ability to assess the whole of the evidence and would reward an attempt to obstruct justice. But the defense fails to see how it would be in the interest of justice for the prosecution to rely on the previous paper accounts of witnesses who have been present in court and have testified before the judges under oath. Sylvia Chebet, Citizen Weekend, Nairobi.